Hello, my dear friends. You know that I have already published one of the link on YouTube that is about introduction. It was decided by myself. It was planned by myself that after the request of my various students, many students have requested me, sir, why not will you take lectures? Even after my some of the colleague professors also requested me. I would like to come to the next point. I told you what is the nature of the administrative law. By this, you can elaborate the things. My dear friend, is examination. You can write the papers. This is a very simple thing. Now, in the next topic is going to concern, I can say the growth and development of the administrative law. Growth and development of administrative law. Now, growth and development of administrative law in the sense, once the administrative law which have been formed, from where this particular administrative law is also came through the British laws, my dear friends, and some of the Indian laws, some other laws have been taken, and the administration law is already formed or framed. By this framing this right, the constitution is giving the power to them. Right now, I told you that they are giving the delegated some powers to them. Therefore, this is the law. Once the law which have been formed, it is to be going to be reviewed again and again, my dear friends, whether it is really going to be helpful to the public or it is going to be hazardous or it is going to violate any right of the public. That is going to be reviewed. Under such circumstances, if any law which is going to be reviewed or going to be further modified or maybe changes or maybe removed or maybe repealed, what we can say right now, they are going to take place. Therefore, the modification for this particular thing, therefore the administrative law, it is going to be grown or ultimately it is going to develop further also for the interest of the public or for the interest of the specifically for the individuals. Now there are some reason of rapid growth and development of administrative law. What is the reason is there? The change in the role played by state. I told you what is a state. State is nothing but a welfare state. It is saying that change in the role played by state, not a dictatorship. हुकूमत नहीं होना चाहिए, but welfare state taking care of citizens. And there is one maxim, my dear friend, what I can say, cradle to grave. One maxim is there, cradle to the grave. To the grave. This is a Latin maxim, what it is going to be say, friends. Now, as per this particular maxim, it is to understand that any individual from birth to death must be, must be, that is administrative law must be protected their rights, their interests from the birth to the death. This is the welfare state as per the administrative law. If anything we are finding which is not going to fulfill the particular law properly for the society. The next point is there. Number two is there. What we can say, inadequacy of the judiciary. Inadequacy of the judiciary. What is the inadequacy of the judiciary? Inadequacy of the judiciary. जुडिशियरी का मतलब मैंने आपको बताया न्याय व्यवस्था. Now, inadequacy of the judiciary in the sense what we can say, this is nothing but slow, non-expert, inadequate knowledge, burden of case काम कर रही है. वो वहां पर कोई experts नहीं है, they are non-experts are the inadequate knowledge maybe to the judges or maybe to any other persons like that who is concerned. Their burden of cases are lying more. Therefore, to recover all these things, right, to friend, to speedily to be done, right, to speedily cases to be solved, right, no, a decision to be given for that, a judgment must be given for that. Under such circumstances, the development of administrative law is required and is going to be developed further. Third point is their slow pace and inadequacy of the legislature. Now slow pace, slowly it is going to work. जो speed चाहिए उसके हिसाब से काम नहीं हो रहा है. Now what exactly is there? Slow pace and inadequacy, the legislature dependent on administrative authorities to frame new rules, etc. Now see friend, legislature in the sense I told you the कायदे मंडल जो है, legislature वो are going to, there is having some inadequacy, proper knowledge नहीं है या proper experts नहीं है और वो बहुत स्लो काम कर रहा है, वहां पर बहुत सारे बर्डन ऑफ केसेस भी पड़े हुए, वो बहुत स्लोली काम कर रहे हैं, उसका नतीजा ये निकल गया डिपेंड। और दूसरी बात ये लेजिस्लेचर टोटली डिपेंडेंट ऑन द एडमिनिस्ट्रेटिव अथॉरिटी बिकॉज एडमिनिस्ट्रेटिव अथॉरिटी इज फ्रेमिंग द rules and regulation. This is a very important thing. Now the next point is different possibility to take preventive action. Point number 4. The court can sue a person for prevention action in future required to be taken administrative authorities, for example adulteration of food, medicine, drugs, etc. Now possibility to take preventive action in the sense what exactly is different. What's a person who is already punished, a person who is already punished, that person once again wants to sue right now. But we hear it further, there should not be the same act to be taken place which is going to be disrupt the society or it is going to create a problem public or individuals. Therefore, under such circumstances, to prevent all this, the preventive action must be taken. The preventive action in the sense, suppose, for example, the police force is there. If any person who is aggrieved, if any person who is a criminal, that criminal who is a punished, after punishment, right now, friend, he should not, the same act should not be take place again in the society, which is going to be create a problem. It is a duty of the administrative authorities, and they are going to prohibit it, my dear friend. They are preventing it. Therefore, some examples are the example is adulteration of foods is there. So medicine, drugs, etc. आपको पता है कि कप सिरप का जो लास्ट टाइम इशू हो गया है तो बहुत सारे बच्चे मर गए. Am I right, friend? Now that is already banned and that is already stopped, my dear friend. Therefore, it is prevented by the authority drug and medicine. Now, friends, further better enforcement. Whatever the administrative law is there, a procedure to be properly enforced. अच्छी तरह से उसको इम्प्लीमेंट करना चाहिए. Now, how it is after taking preventive measures, it must be enforced in the future by the way of ban or cancellation of license, etc. तो किस तरह से प्रिवेंट किया जाता है? तो जो आपको जो प्रिवेंशन का जो रूल्स है वो प्रिवेंशन का प्रॉपरली उसको एनफोर्स करना चाहिए और उसके हिसाब से व्हाट हैपेंड राइट नाउ फ्रेंड द लास्ट इंसिडेंट आई टोल्ड यू राइट नाउ दे ऑलरेडी बैन their companies as well as and ban the product also as well as they cancel the license of the company. This is a basic point is there, friend. This is the fifth point what we have studied. Now the next point is the friend what we are talking about the practical and functional approach of the administrative authorities. Sometimes courts or tribunals avoid the theoretical and technical aspect but applies practical ways too. In the sense what? You know, friend, there is a procedure of the judiciary machinery, judiciary as well as the administrative authorities also, friend. Now, what is the practical and functional? What I'm saying right now, they do both the things they are lacking somewhere in the practically as well as the functionally approach. Under such circumstances, the judiciary is giving the decision in a such manner, or tribunals are giving the decision in such manner that they are not taking the practical and functional approach of the administrative authority. In the sense, they are taking the practical functional approach and they are not looking for any technical or theoretical aspect is concerned and giving the decision for that, giving a justice to concerned person. Next point is a combination of function and policy information formation. Now, friends, you know combination of function and policy formation. Combination of function of what, friend, and policy formation of what? Every policy matters are going to be made by the authority. To frame policies, administrative authorities exercising combination of quasi legislative and quasi judiciary function. तो क्वासी लेजिस्लेशन मतलब व्हाट इज देयर, कायदे मंडल का जो कुछ अधिकार है वो अधिकार यहाँ पर आप एडमिनिस्ट्रेटिव अथॉरिटी भी यूज कर सकते हैं. आई विल एक्सप्लेन दैट आफ्टरवर्ड्स आल्सो, फ्रेंड. एंड क्वासी जुडिशरी मतलब जो जुडिशरी का जो कायदे का न्याय व्यवस्था के जो अधिकार है वो भी यहाँ पर एडमिनिस्ट्रेटिव अथॉरिटी यूटिलाइज कर सकती है, यूज कर सकते हैं फॉर द इंटरेस्ट ऑफ द पीपल, फॉर द इंडिविजुअल्स. नाउ फ्रेंड, द 8 point is the friend what I am saying that policy implementation better to implementation after formation of policy. That means what after the formation of policy it will be better to utilize my different implement and this policy is going to be implemented in the society. For example, is different workmen's compensation, labor relations, etc are the one of the example there. Therefore scope for flexibility and experimentations. Now for to develop these particular things and to grow the particular administrative law, what is the basic aspect? There should be a proper scope and the flexibility and experimentation. उसका experiment कर सकते हैं इस तरह से the scope for flexibility and experimentation in the sense this must be helpful to the public and to the individuals. Thank you very much, my dear students. Now the question may be asked, what is the growth and development of the administrative law? You can answer this. Thank you.